Hello students, welcome to all of you on behalf of the Unique Academy on this discussion series on ongoing UPSC Civil Services Mains Examination. We have already conducted special session on essay followed by the three subjects of GS1 followed by another discussion on international relations by Pankaj Bhatte sir, and today we are going to discuss GS2 in special reference with Indian polity and governance. What I am going to do today is to elaborately discuss all 16 questions which were asked by the UPSC on Indian polity and governance. Generally, whenever we look at the previous year question papers, the very purpose happens to be to get to know the direction, the kind of questions which are asked by the UPSC, so that we can learn in order to design one's own strategy for the coming examination, obviously the mains examination. Let us get started with the very first question. Discuss the corrupt practices. Let us underline the important point. For the purpose of Representation of People's Act 1951. Okay, so the question pertains to the act, but something very, very specific, the concept of the corrupt practice. Okay, and we'll underline it in a different manner. Mark it in a different manner. Now, analyze whether the increase in the assets of the legislators, okay, what increase in the assets of the legislators and or their associates now disproportionate to their known sources. That is also very, very important. Disproportionate to the known sources of income. Now, would that constitute what? Undue influence and consequently a corrupt practice. Okay. Now, there are two parts of the question. So, first part refers to the Representation of People Act 1951 in reference with the corrupt practices. And then the second part pertains to that issue, that problem which is recently dealt with by the Supreme Court of India, and a very important judgment of Supreme Court of India came in 2018. We'll look into that. So, and that issue pertained to something called as disproportionate asset, okay, to their known source of income. Now, here, what the question does is to focus on the legislators, the representative of the people, but we can expand that to include all public authorities. But since the question expects us to focus on the legislators, that is the representatives, will stick to that point. Now, I'm sure you must have read the act multiple times and there are a number of factual details. Okay, but whenever something happens in the ongoing year, previous year, or in recent times, then you have to focus on that aspect of the act. So, the issue of disproportionate asset, okay, to the known source of income, if that is something which is in news, then we have to get back to the act and look out for that pertinent aspect. And that is what we have. So what are the corrupt practices? We have just included a few: bribery, appeals to the caste, race, community or religion, spreading falsehood, the propagation or the commission of sati, booth capturing, okay, then promoting enmity, incurring or authorizing of expenditure in contravention of section 77 of the same act. So, the first part of the answer has to deal with something called as, we have underlined that, corrupt practices. Very precisely, very sharply. And then the point B deals with the second part of the question. And I guess the second part of the question expects you to argue. You are supposed to take a position whether whatever is asked in the second part constitute undue influence and subsequently the corrupt practice. Now look what we have done here. Disproportionate asset is not explicitly mentioned in the Representative of People's Act 1951, but it certainly constitute, we have very categorically stated this, an undue influence. Why? Now this follow-up explanation is very, very important. You cannot argue in a very generic manner. You have to be very, very specific. Now, it undoubtedly suggests the misuse of his/her position, okay, by a legislator for illicit financial gain. Now, without this kind of influence, it is very, very difficult to accumulate that kind of money. The second one, such financial assets in turn are misused in various ways to influence the electoral process. Okay. In other words, in the words of Supreme Court of India, this observation is very, very critical. Accumulation of wealth beyond source of income paves way for rule of mafia. Look at the word used by the Supreme Court of India. The rule of mafia substituting what? The rule of law, which happens to be a very foundational principle of all modern political systems and obviously democratic systems such as Indian democracy. Okay, so the two important arguments, then let us take it forward. Thus, it leads to a vicious cycle of use of political power for accumulation of wealth and using such wealth to gain power, to maintain power and increase power. So this is the kind of vicious cycle which emanates from the earlier two processes. Hence, once again we have got back to the Supreme Court's observation. Supreme Court bench headed by Justice Chelabeshwar in Lok Prahari versus Union of India case 2018, while deciding on matter of disproportionate income of representatives, directed that not just representative candidate, but even, this is very important, spouses and dependents should henceforth divulge their assets and source of income while filing the nomination. So, this income background not only of the candidate who is going to contest the election, who is already elected and happens to be representative, okay, उनका तो source of income और क्या हुआ वो तो देखने वाले हैं, लेकिन court ordered to also look into the income of spouses as well as the dependents, and that is a very important observation by Supreme Court of India. Okay, now as the Supreme Court suggested, this is how we have concluded the answer. As the Supreme Court suggested, it is essential to establish a permanent mechanism. So students, whenever you read some write-up, news pertaining the judgments, observations, orders of the Supreme Court of India, you should pay attention to those important aspects, okay, which can be utilized effectively in order to support one's own argument. So the Supreme Court, as suggested, it is essential to establish a permanent mechanism to periodically collect data of legislators and associates and examine. Now, what is the purpose? To examine the disproportionate increase in their assets and recommended action against the same one. So this is how you are supposed to design your answer. So the first part of the answer deals with the concept corrupt practices as per the Representation of People's Act 1951, and the second part, disproportionate asset to the known sources of income. Do they constitute, can we look at them as undue influence, okay, as a mark of undue influence, and therefore subsequently the corrupt practice. So now these are the four parts, very specific arguments which support the main part of the argument. Okay, so this is how you are supposed to take it forward. Now look at another important, I actually refer to the same question in my introduction. Comment on the need of the administrative tribunals. Now, this part of the question per se focuses on the static, traditional, fundamental aspect of the administrative tribunal. Okay, and what is that? Need. Why do we need administrative tribunals? Compared to the court system, that is the routine, usual court system. Assess the impact, now let us underline that, of the recent tribunal reforms, and this is how they combine the static with the current. The recent tribunal reforms through rationalization of tribunals made in 2021. Okay, so actually this process gets back to even 2017, because a very important initiative by the Union Government of India was taken up. It was challenged in court of law. In 2021, Supreme Court of India gave its judgment, and then as a follow-up action, another act was taken up by the Union Government. Okay, so this is how the process unfolds. So there are two important parts again: the need of administrative tribunals, and then assess the impact. Okay, now impact of what? something which has recently taken place, and recently means in the year 2021. So broadly we can say there will have to be two parts of your answer. Okay, and let us take note of that. The mechanism of administrative tribunals has evolved in modern times, especially in the 20th century, due to the expansion of responsibilities of the state. And in mid-20th century, what we get to see is the welfare state. Now, state was, because of the welfare state, not limited only to the law and order, but the responsibilities and the roles of state as an institution expanded. Okay, health, education, rural development, so on and so forth. Okay, and development, importantly, of vulnerable sections, neglected sections of the society. Now, the need of the administrative tribunals, and we have done it very specifically, and that is what we are supposed to follow. To reduce the workload on the judicial system, I need not look into the explanation. You can explain that. So look at the titles. To reduce the workload of the judicial system, provide expertise. Now, if we are talking about administrative tribunals, then the sphere administration is a different sphere from that of the judicial sphere. Okay, and we can point out, underscore such so many other specialized spheres like administration. Then the third is the flexibility. Now, in what sense flexibility? I am sure you must have gone through these basics. You can look into that. And ultimately, these tribunals as well ensure fair and impartial dispute resolution. So these are the four important arguments, let us see, in the form of 4 points, which explain the first part of the question. Now, taking it forward, now the recent reforms with the objectives to rationalize the tribunal system by reducing the number, to ensure uniformity in administration and efficiency by eliminating duplication. So we have also pointed it out. Merge tribunals based on the functional similarity. Lack of specialization in regular court may affect the decision making in certain specific domains, such as the film certification. Now, you must be surprised to know in what sense these recent reforms are going to influence. There is no doubt that tribunals have been merged as far as this logic is concerned. But then it is also going to result into increase in the burden of the routine court system and judicial system. Now, what about the specialization? Okay, so how are we going to ensure the same aspect? So that is another issue. And in certain specific spheres, okay, expertise pertaining to that sphere is also important. Now, abolished around 8 appellate tribunals and transferred their functions to existing judicial bodies, especially the High Court. Now, that is where the recent reforms, okay, reflect certain concerns. Okay, and this is another concern because it is going to add to the burden of the High Courts. Then give the central government the powers to make rules about the conditions of work of the chairman and the members of the tribunals. Now, look at the issues. So we just pointed out 4 important parts of the recent reforms pertaining to the administrative tribunals. Now, what are the issues? It will contribute to the burden of high courts, and look at the pending cases. The figure is 60 lakh from across the high court. As a result, it will take more time to dispose of the cases. Okay, because if you add to the burden of the high courts, then it is obviously going to take more time, and then it does defeats the very purpose with which the tribunals were set up. Okay, so therefore, as Supreme Court of, and again we have gone back to Supreme Court's observation made in 2019, directed the government that it should undertake a judicial impact assessment of such amalgamation of tribunals and make essential changes. Okay, so what we have done as far as this answer is concerned, to the basic logic behind having administrative tribunals. Then the second one, the recent reforms focusing on the 4 important elements of the same. And the most important part, because this is what specifically asked by UPSC in the second part of this question, assess the impact. So these are the issues. Okay, so this is how we can take it forward. Now let us look into the question number 3. This year UPSC had asked 2 questions on comparison, that is comparison of India and comparison of US. Okay. Now, these two questions are on India-US comparison. So, one question, the something which we are going to discuss, pertains to the presidential pardoning power, president's pardoning power. And the another question is on the appointments of the judges. Okay, now let us get started. Compare and contrast the president's power to pardon in India and in the USA. Are there any limits to it in both countries? What are the preemptive pardons? So there are three main parts of the question. Now the USA and India, despite being democracies, this is a very interesting introduction which explains the logic behind, the reason behind the differences. Okay, represent two different forms of schemes of sharing of power. In India, we have parliamentary system with federalism, whereas in US, they have the presidential form of democracy with a classical form of federalism. It is manifested in the different position and varying powers enjoyed by the presidents in both USA as well as Indian political system, and that is in turn reflected, manifested in the differences in the power pertaining the pardoning power. Now, one by one, the Indian president enjoys the pardoning power under Article 72, but must be exercised on the advice of the Council of Ministers headed by Prime Minister. Whereas in US, under Article 2nd of the US Constitution, the president can exercise this power independently. Okay, so that word is important, and at his/her discretion. So, what we have done in this first point is to explain the pardoning power, but along with that, we have also identified, underlined the difference as well. Okay, now Indian president's power applies to convictions by state and union government. This is very important. Whereas the US president's power is limited to the federal offenses only. This is another difference. So it does both explanation of the power as well as the difference between the two. Moreover, in the USA, this power does not extend to impeachment cases. Now the third, in the Indian case, the judicial review of such pardon is available. Okay. But that too in rare cases, whereas the decision is deemed wholly irrelevant, irrational, discrimination and malafide. So this is a limitation. However, if you look at the US president's pardoning power, then that limit does not apply. The president is not answerable for his pardons and does not have to provide a reason to issue the same one. Now, this is how through these 3 points, we have not only explained the pardoning power of both the presidents, but while doing that, we have also jotted down the differences as well. Now, a small write-up on the very concept preemptive pardon, and it was in news because the present president of USA, Donald Trump, has applied that. Okay, and we have made mention of that. The US president cannot preemptively pardon future criminals. Okay, not future, but can pardon individuals. Okay, let us underline that. Cannot do it preemptively, but can pardon individuals for crimes already committed. Now, even before the charges are filed or sentence is imposed, for example, the president, US president, exercised his power to pardon his former national security advisor, Michael Flynn. Okay, so per se, this question can be included in the category of a factual question, but nonetheless, it has current dimension because presidential pardoning power came into discussion, recent debate because of the recent developments, we know for sure. Okay, now take it forward. Now, this is a very interesting question asked by UPSC. Article 370 was abrogated, and through a new act, the very nature of the state of Jammu and Kashmir was reframed, reorganized. Now, somebody would have thought that UPSC may not ask a question on the same because today Jammu and Kashmir happens to be UT. Okay, however, soon it may have to transform into the state. So somebody would look at this arrangement, the present arrangement, as a transitional arrangement, but nonetheless UPSC did ask a question on that. So discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. and briefly describe the powers and functions of Assembly of the Union Territory of Jammu and Kashmir. Okay, so this question also may fall in the category of factual question. Okay, now J&K Reorganization Act 2019, these are mere facts. The state legislature shall be unicameral, unlike the earlier bicameral legislature. So the present assembly legislature has only one house, that is the state legislative assembly. Now this is going to comprise of 90 members and another 5 can be nominated by the LG. Okay, the assembly shall have 5 years. So these are mere factual aspects of the assembly. Now, as far as the powers which are enjoyed by the state legislative assembly is concerned, section 32 of the Act of 2019 pertaining the reorganization of Jammu and Kashmir deals with the extent of law-making power of the legislative assembly. And this part deals with the second part of the question, one by one. The assembly can make laws for the UT with respect to any matter listed in state list, but there are 2 exceptions, and let us underline those exceptions: public order and the police. Okay. Second, it will not obstruct Parliament from making laws regarding the union territories which are bestowed upon it by the Constitution. Okay, and this does not apply to legislative assembly of a usual routine state. Okay, so this is the second one. The third one, for the concurrent list, the UT can, that is the union territory, can make laws only until it is applicable to Jammu and Kashmir only, whereas the states have more liberty on the concurrent list and can make laws until the legislation is not contrary to the laws made by the Parliament. Okay, so these are important differences. Now the fourth one, this is significant. The assembly will also be dependent upon the LG. Okay, for introducing the finances bill. The finance bill can only be introduced in the legislature after the recommendation of the LG. So this is another important difference. Thus, the powers of the legislative assembly are restricted in nature. Now, what is important here? Every year, you may find out 3 to 4 such questions, which are sort of fall in the category of surprising questions. We must have taken it for granted and not paid due attention to that. Let us not let that happen with us. Okay. Now, the fifth one, I haven't come up with the model answer as far as the fifth question is concerned because it is very factual and straightforward. But nonetheless, let us look into that. And every year, again, I'm repeating it, such factual question, a couple of questions that, let us say, are likely to be asked by the UPSC. Attorney General of India plays a crucial role in guiding the legal framework, okay, of the Union government. Now, the question is obviously on Attorney General. On what? Guiding the legal framework of the Union government and ensuring what? Sound governance through legal counsel. Okay, so legal advice. Discuss his responsibilities, rights and limitations in this regard. What? Responsibilities, rights and limitations. So these 3 aspects are very, very important. Now the first sentence, the very opening sentence of the question seeks to capture, okay, the position and obviously the role of the Attorney General. No doubt about that. But then the second part of the question focuses on 3 aspects or elements. So responsibilities, rights and limits as well. This is significant. Now this is very interesting. Women's social capital, okay, complements in advancing empowerment and gender equity. Now there are 2 important parts. So the first part pertains to social capital. So how does social capital help, assist in the process of advancement of women in terms of empowerment as well as the gender equity? Okay, very precise. Women's social capital, the value women derive from their social networks, connections and community bonds. It is one of the channels through which women's empowerment can be ensured and it can lead to increased economic well-being and the empowerment of women. Now here you have to establish how this is going to help empowerment as well as the gender equity. So while establishing that point, certain aspects are to be focused by you, no doubt about that. Economic empowerment. But how exactly? Can we cite out one example? So I have just broadly referred to something called as the self-help group. Okay, microfinance you can say. Then information and knowledge sharing. Okay, about various matters. Right from a little matter, okay, to a generic question. Number 3, the collective action and advocacy for both to fulfill their demands and to take action against various problems faced by them. So this collective action and advocacy is very, very important. Then 4th, improved decision making. Now, effective presence in local self bodies. Now, there has been a term which is coined in regard with local self government, that is the Sarpanchpati. Women have presence in the local bodies, both urban as well as the rural bodies, but their presence has not been effective because of the influence of, okay, the men. If women are better equipped, especially those who have entered the local bodies, then they can utilize their social capital very effectively, and thus we can get to see not only just presence of women in local bodies, but effective presence of the women, those representatives. Okay, so therefore it is likely to contribute to the efficiency of and the effectivity of their representation in the local bodies as a representative. Health and well-being, yes, that aspect would be taken care of in a more aware, effective and efficient manner. Now, how can we possibly ensure of these 5 aspects? Okay, wherein their social capital contribute both empowerment as well as a gender equity. So there is one means which is very, very important, education and training. And when we say education, here we are not essentially talking about the formal education. Okay, so let us make it broad. And then gender sensitizing in various aspects. So be that local bodies, be that administration, right from local to the union level administration, and importantly the civil society. So this sensitization is very important. And as we have right at the end of the answer underscored, examples are key in these kinds of questions. Okay, so this is the 6th one. Now taking it forward, this is a question on e-governance. We can make it simple. This question, simply speaking, deals with, ask explanation from students about the problems of the e-governance. But problems in general are not asked by UPSC, but a very specific problem, pinpointed तरीके से उसको पूछा गया है. E-governance projects have built-in bias towards technology and back-end integration, then user-centric designs. Okay, so this is a statement and exam ने ऐसा बोला है. So while designing e-governance project, what is prioritized and what is not prioritized? Not given due attention. So what is prioritized? Technology and back-end integration. Okay, so it is something which is done by the government, by the administration, keeping in mind their convenience. But hardly the users are taken into account. So therefore the question expects you to make an argument, a solid argument obviously, to underscore how if this kind of design is made and adopted and implemented, this is going to fall flat on its face and it would not be efficient and effective e-governance project. So always keep in mind that. So user-centric design. Now e-governance and technology back and integration. What we have done is to just in plain and simple language explain that. The process of connecting and enabling data exchange between different government departments and their internal IT system to create a unified, interoperable and efficient service delivery model. Now, this is usually done by government, by the administration, keeping in mind their requirements. Okay, but then there are multiple issues in the e-governance projects, but the question focuses specifically on the users. So we have specifically written here, lack of user involvement in the design process. Now, if that is the case, then it is going to be very, very difficult to understand the needs and requirements of the user. Okay. Bureaucratic processes designed internally rather than around the user needs without knowing the needs of the user and consulting them, without consulting them. अब result देखिए क्या होता है. As a result, the services remain opaque, rigid and alienating the users. So this is the biggest problem as far as these kinds of projects are concerned, or designs are concerned. Now, inconsistent design elements and poor accessibility. Now, if you have not taken users on board and not taken note of their peculiar needs and requirements, then whether you can ensure the access to that design or application remains out of question. Number 3, outdated digital interfaces. Now, this is a very interesting feature featuring outdated designs such as old style button designs. So that upgradation and user friendliness is very, very important. So you have to go on upgrading the tools. Now, poor usability because of certain aspects, then difficult complex language, use of very legalistic language also discourage the users from accessing those services. Then there are operational issues such as internal bottlenecks, limited resources, and lack of technical upgradation. So thus, these are the 6 important issues, concerns, or problems when the design pertaining e-governance focuses on the needs and requirements of the government and administration and does not pay due attention to the users. Okay. So therefore, yes, the question per se is about the problems involved in the e-governance project, but it is very specifically focuses on one broad aspect of the problematic aspect, that is the users, that is the people. This is a very interesting question as it seeks to assess the critical thinking and argumentative ability of the student. Civil society organizations are often perceived as being anti-state actors. Then let us underline that, anti-state actors rather than non-state actors. Do you agree? Okay. There are 2 terms pertaining civil society. So what is the main topic? That is the civil society, obviously, civil society organizations. But they are looked at as not non-state actors, but rather anti-state actors. Okay. So at least 3 important aspects need to be part and parcel of your answer. So the first obvious would be what is civil society association with examples very briefly. And then straightway you have to focus on are they really anti-state actors? And if yes, if there is a point of view which subscribe to that view, then what are the reasons? And then importantly, is that true? To what extent that is true? Can we look at, or are civil society organizations looked at, seen as what? The not anti-state actors, but rather the non-state actors. Okay, let us check it out. Now, in a liberal democratic setup, civil society is seen as a non-governmental sphere comprising various associations, right from your family to the media, the old one, the new one, the electronic, so on and so forth. Okay. Now, from the democratic view, this point is very important. The civil society associations are understood as a domain of freedom and autonomy. This is very significant feature of the concept of civil society, but from the democratic perspective, from the liberal democratic perspective. Okay, this is how we look at civil society, because in civil society, we are free to choose whatever we want to choose. Okay, and therefore it is looked at as the sphere of freedom and autonomy. Now, in the era of liberalization, okay, something important has happened about the civil society. And what is that? In the era of liberalization, the state has retreated from so many domains, and the vacuum created because of the rollback and retreat of the state, as if it is filled up by the NGOs, the voluntary associations, the private sector, and all these are taken as part and parcel of the civil society. So what has happened broadly in the era of liberalization? The retreat of state on one hand, and number of organizations, associations which are part of civil society as if they have come forward. Okay, and this is a very interesting process which has taken place about the civil society. On one hand, these associations have contributed. Now look, this is very interesting. So if they have come forward, then what is the consequence of that? Okay, number one, this first aspect, these associations have contributed to the empowerment of people, and on the other hand, through various ways, and on the other hand, have pressurized the government to ensure transparency and accountability. This is a very interesting facet feature of the civil society. Okay, in what way it has empowered the people? By creating awareness, so on and so forth. But then there is another important role played by civil society, that is pressurizing the government for more and more transparency and accountability. And we have referred to one example, that is the Right to Information Act and MKS role. These associations thus try to influence the government decision-making process in various ways. Now, moreover, the civil society institutions tend to take a critical position on any attempt by the government which either limit their freedom or impose its will in the name of the public at large. So this is another very important facet of the role of the civil society. And let us read it once again. So every attempt by the government or by the state which seek to limit freedom or liberty, that is opposed by the civil society organizations, because as we started right in the beginning, civil society is seen as the sphere of autonomy and freedom. So therefore, they tend to always critical of any kind of government move which seek to limit the freedom or liberty. Then there is another attempt which is always come from the state, and that attempt happens to be imposing its own will as the will of the people, in the name of the people. And we have just cited out one relevant example, anti-corruption movement in 2011. Now, on a number of occasions, the environmental NGOs have opposed developmental and infrastructure projects for environmental concerns. So that is another important facet. Thus, these associations have played an important role in creating awareness in civil society on one hand and holding government accountable on the other hand. So we took up 4 or 5 important aspects of the role of the civil society and then concluded. This conclusion is very, very important. Now look at the important aspect of the argument. However, and let us point it out categorically. However, now you must have sensed that we are going to enter into the argument per se. There has been significant erosion of trust, okay, in these associations, especially the NGOs, due to a number of, and we have jotted down the issues: scandals, financial irregularities, sexual abuse of vulnerable beneficiaries, and accusation of foreign funding and the mission drift. Now, this part is very significant. You can mention these issues pertaining the civil society organizations, and I have focused on NGO per se here, one by one. Okay, because this is something which comprise of a set of issues and concerns pertaining civil society, and it is because of these concerns that the above mentioned point of view is put forward. Okay, so they are not seen as non-state actors, but rather they are seen as anti-state actors. Okay, these institutions are seen as anti-state due to the dissenting voices as well as the irregularities involved in these associations. So these are very 2 specific broad dimensions, okay, because of which this critical point of view is put forward. So one is the dissenting voices, the critical voices, because they do focus on freedom and liberty concerns, autonomy, but then on the other hand, the sphere, the domain of civil society itself, okay, is faced with certain issues and problems. So taken both of them together, they tend to be seen as what? Anti-state rather than the non-state actors. However, look at the conclusion. The conclusion is equally important. However, this observation cannot be generalized due to a few bad apples, okay, and due to their critical view of the establishment. ये नहीं कर सकते हम. The role of partnership that they have played, and this partnership is very important, and I explained that in the form of a passing reference. that they have played till date, as mentioned above, should not be ignored. So that is how you are supposed to build your argument. Civil society, what has he done, especially in the age of globalization and liberalization, and then the critical way of looking at civil society and why that critical point of view. Okay. Okay, so here ends the first set of questions from first to the 10th question, and I'm focusing on the questions on Indian polity and governance. Now from 11 to 20th, all of you know, these are the 15 marker questions, okay, to be answered in 250 words. Constitutional morality is the fulcrum which acts as, and let us underline the important parts of the question, constitutional morality as a fulcrum which acts as essential check upon the high functionaries and citizens alike. So, what does constitutional morality actually do is what this statement seeks to capture. Now, in view of the above observation of the Supreme Court, explain the concept of constitutional morality. So, explaining the concept and its application, okay, to ensure balance between two things, that is the independence and judicial accountability. So, one of the 10 observations that we initially saw is this one. That is, A, you are supposed to be fully aware of the concepts, okay, but then on the other hand, you should also be able to apply those concepts. Now here, the concept of constitutional morality is to be applied by you in a very peculiar sense. Now, where to maintain, to ensure the balance between judicial independence and the judicial accountability. Okay. Let us look into that. And I have written a detailed answer of that so that you can get to know all aspects of that. Dr. Ambedkar employed the notion of constitutional morality during the assembly debates. Okay. And underline the relevance of new morality grounded not only in the text. This is very important. So, constitutional morality does not mean the provisions, okay, the technical details of the constitution alone. That is part of that. But, so that is the text, simply speaking, but it is also about the spirit. What is the rationale behind that? What is the reasoning behind that? Okay, so that aspect of the constitution and thereby the constitutional morality is very important. As Pratap Bhanu Mehta, we have brought in one scholarly opinion, pointed out that it means substantive content of the constitution. It is not just the formal content of the constitution, the factual, informative provisions of the constitution, but it also contains what? The substantive one. So this is how Pratap Bhanu Mehta explains the concept of constitutional morality. In this sense, constitutional morality, and that is how we have concluded, is morality of our constitution. Okay. Now, so this is a kind of introduction. Take it forward. Now, Dr. Ambedkar, by drawing on the work of British classicist George Grote, elaborated the concept. Now, this is a quote by Dr. Ambedkar. The habits of the permanent reverence for the form of constitution, okay, we have underlined that important part, reverence for the form of the constitution, enforcing obedience to the authorities, acting under and within these forms, okay. Now, you have to obey the authorities, but not those authorities which conduct themselves arbitrarily, but those authorities which form, okay, the constitution. So therefore, this is very, very important, which operate under and within these forms, yani ki limits of the constitution. Yet, combined with the habit of open speech, that speech is also very important, of action subject to definite legal control and unrestrained censure of those very authorities as to all their public acts. This is a very interesting statement by Dr. Ambedkar, which is quoted, which captures the gist of the concept of the constitutional morality. Okay. Now taking it forward, the Indian judiciary has been playing an important role in imparting prominence to the notion of constitutional morality. And court has been doing this by interpreting constitution not only in a textual manner but in a substantive manner. You can refer to Article 21 as to how court, that is the Supreme Court of India, expanded the ambit of Article 21. So not only the textual and formal reading of constitution, but also reading constitution by keeping in mind the spirit behind those provisions. That is very important. That is the substantive reading of the constitution. Okay. And to be specific, court in recent judgments has employed the concept of constitutional morality in certain judgments. Okay. The Indian judiciary has been playing an important role, imparting prominence to the notion of constitutional morality, especially due to the invocation by the courts in crucial cases such as decriminalizing same-sex consensual relations under 377, Triple Talaq and Sabrimala, where there seemed to be a clash between popular morality and constitutional values. Okay, there's only a constitutionally created independent. So this is the conclusion. So what court has been doing pertaining constitutional morality, it has been using that concept, okay, in order to settle certain very delicate disputes. Now come to the conclusion. Thus, only a constitutionally created independent and autonomous judiciary can play this kind of role. So if constitutional morality is about both text as well as the spirit of constitution, and if that concept expects reverence to the same text as well as the spirit of the constitution by both, that is the people of India and all the public authorities, then Indian judiciary is very, very important here, rather critically important. And only independent and autonomous judiciary can play the role. However, so that was one aspect. And we need not explain the necessity of judicial independence and autonomy because it is quite explicit and quite clear. But the second point which is made a mention of in the question is judicial accountability. So independence is no doubt essential, but it has to come along with another aspect, that is judicial accountability. However, the constitutional morality also demands accountability on part of all public authorities, because constitutional morality first of all is about that. So public authorities also are bound by the text and spirit of the constitution. So that text and spirit is not only binding and obligatory for the people at large, but even the public authorities. Okay. So, and one important part of the code of conduct of public authorities happens to be accountability. Okay. And therefore, that accountability also applies to the judiciary. Not only independence, but the accountability as well. Okay. It becomes critically important given the strong position acquired by the Indian judiciary in the form of doctrine of basic structure, public interest litigations, judicial activism in contemporary Indian polity. Now, there is no doubt that Indian judiciary has emerged as one of the strongest judiciary, okay, undoubtedly, due to these means and instrumentalities. Okay. Now, precisely that development in the realm of Indian judiciary demands a commensurate accountability from the same judiciary. So therefore, we cannot isolate the issue of autonomy and judicial independence from the accountability. Both of them should go hand in hand, and there has to be a balance, there has to be an equilibrium. So we have focus on that aspect. So that is critically important. Judicial accountability, equally essential for, we have come up with very specific points, one by one. The existing checks on judiciary are very limited. Okay. Always keep in mind that they are very limited. The important one being the impeachment procedure. That is significant, no doubt about that, but that is something which is used on rare occasions. Okay. The second, hence, the most important control on judiciary is the self-control and self-restraint. Okay. The third, the collegium system of judicial appointment needs to be made transparent and accountable, as judiciary happens to be the ultimate authority to appoint the member of the judiciary. So collegium system. Then Moreover, the doctrinal basic structure also needs to have more clarity and a reasoned and principled approach, because there is still a lot of ambiguity, there is disagreement, and there is a serious critique by a number of scholars of the doctrinal basic structure for not having enough clarity and a reasoned approach as far as the doctrinal basic structure is concerned. Therefore, there needs to be more clarity as far as the doctrine is concerned. The necessity of establishing a grievance redressal mechanism for the purpose of resolving various matters involving, importantly, allegations of corruption and other misconducts by the members of the judiciary. So these are 5 very precise and particular points which underscore the need of accountability on part of the judiciary. Okay, so this is how we can elaborate upon our position. Now this 12th question, Indian Constitution has conferred the amending power on the ordinary legislative institution. Okay, what? Ordinary legislative institution. And Parliament is the main legislative institution, and in connection with the federal issues, there is also participation of the states, at least the half of the states, we know for sure, with a few procedural hurdles. Okay. In view of this statement, examine the procedural, and the second part focuses on explanation of the limitations. So yes, the power, the authority to amend the constitution is conferred upon what? The ordinary legislative institution. So one is the parliament, but most of it is parliament to certain extent in federal, in connection with federal issues, the half of the states, okay, involvement of the state. And then the other part, the subsequent part of questions, seek to explain what the procedural and substantive limitations on the amending power of the parliament to change the constitution. So the first statement is a factual statement. You have to briefly bring it out, no doubt about that. But then the second part is very, very important, and you have to elaborate upon the procedural as well as the substantive limitations of the amending power. Sorry, just a minute. So it has 3 methods, you know for sure. Parliament's amending power. Now, very specifically, the procedural limitations. The procedure has to be in accordance with Article 368, no doubt about that. The bill can be introduced in any house, okay, but not in the state legislature. So the initiative of amending constitution in the form of the constitutional amendment bill has to emanate from either house of the Indian Parliament. The third, it needs to be passed by both the houses of Parliament with a special majority, but in some cases, even a simple majority is sufficient. You know all the 3 methods especially. There is no provision of joint sitting in the case of the constitutional amendment. Okay, we know for sure that is another procedural limitation. Both the houses of Parliament have to pass the constitutional amendment bill. Now, any bill seeking to amend the federal provision must be passed by at least half of the state, besides the 2/3 majority by both the houses of the Parliament. And then the last part, as far as the procedure is concerned, it is the presidential assent to the constitutional amendment bill. Yes, now let us turn to the substantive limitation. That is the second part of the answer. Per se, there happens to be one substantial, very important limitation on the amending authority of the Parliament. Obviously, that is the judicial review. Okay, and I'm sure you must have read about the amendments done by the Indian Parliament on one hand, and those amendments challenged in the Supreme Court, yani ki court of law, on the other hand. So the first amendment, Shankari Prasad, landmark case, then Golaknath, and then comes the Keshwanand Bharati. And in Keshwanand Bharati, in the form of the doctrinal basic structure, the Supreme Court of India brings clarity as far as the judicial review of the amendment is concerned. And it is through this doctrine, Supreme Court clarifies, and that case, famous case, is obviously the Keshwanand verdict. What did Supreme Court of India say? Parliament can amend the constitution. However, that authority of amending the constitution cannot be used by the Indian Parliament to destroy or to damage or to interfere with something called as the basic features of the Constitution of India. So this is how the Keshavananda judgment and the doctrine of basic structure emerged as the substantial limitation on the Parliament's amending power. So doctrine of basic structure. And this is quite interesting that Keshavananda Bharati onwards, this doctrine has been employed by Supreme Court of India in number of cases, and we have just referred to those relevant cases. Minerva means judgment, and that judgment comes in the aftermath of the 42nd Amendment Act, which was undertaken during the emergency. 42nd Amendment Act. Now, S.R. Bommai verdict, one aspect was the secularism, but the another important aspect for which the judgment is important, that is the federalism. That is, secularism as well as federalism were included in the doctrine of basic structure. That is the list of doctrine of basic structure. Then comes the I.R. Coelho case of 2007 pertaining the 9th schedule. And here, once again, the court clarified that Parliament can amend the Constitution, make laws, and those laws can be included in the 9th schedule. However, any law included in the 9th schedule can be reviewed by the judiciary, and that doesn't require a constitutional bench, but the review of the 9th schedule can also be done by a normal bench. Okay, and this is very, very important. And the last significant development pertaining the doctrine of basic structure happens to be the National Judicial Appointment verdict in 2005, which struck down the 99th Amendment Act. So, substantive limitation is one. That is the doctrine of basic structure. That is the judicial review. But you have to elaborate upon by referring to and bringing in the relevant examples. Okay. So, the 12th question. Now, the 13th one. Discuss the evolution of collegium system in India. Evolution. Let us underline that. Evolution of collegium system. Critically examine the advantages and the disadvantages of the system of obviously appointing judges of the Supreme Court of India and the USA. So, the first comparative question on India-US, President's power of pardoning, and this is the second comparative question. Okay, one by one. The two significant developments. So, the first is about what? The evolution of the collegium system. Okay. We have briefly dealt with the evolution, but you have to be very, very specific about that. Two significant developments in the decade of 70s laid the foundation of rise of collegium system in India. Now, which are those two important developments? So, one, the Union Executive sidelining the well-established principle of seniority, okay, in the appointment of judges in general, but importantly, the Chief Justice of India in particular. Okay, so that well-established principle of seniority was kept aside, and the year is 1973. You can check it out. Now, the second major development is the national emergency, and the judiciary, okay, could not hold the government during emergency accountable to people in general, and therefore that is seen as failure of Indian judiciary as far as establishing the government accountability during that period is concerned. So these are two very significant developments which laid the foundation of the rise of something called as a collegium system. Okay, so I have just jotted down the certain points. So the first judge's case, the second judge's case, and the third judge's case. You can just very briefly elaborate upon all these cases. Okay, the issue has to be focused on with that background. Now, advantages and disadvantages. I have just focused on two main points as far as the advantages are concerned, and underline three important points. Now, autonomy of the judiciary. So, whenever we talk of appointment of members of any mechanism, any institution, association, then autonomy matters a lot. Okay, interference of another institution should not hamper, okay, the autonomy of the concerned public authority. Now, here we are talking about the judiciary. So, autonomy of judiciary from the excessive executive interference in the functioning of the judiciary. Now, meaningful control over the legislature and the executive, that is the other branches of the government. Meaningful control. Because in a democracy like ours, the principle of separation of power, the first aspect, but then checks and balances, the second aspect, okay, determines to great extent success of democracy. Okay, therefore, autonomy, the essential part of the same scheme, but nonetheless, the control aspect also is important. Now, what are the disadvantages? Now, collegial system is that system, to put it in a simple way, that the members of the judiciary are almost appointed by the judiciary. Okay, and there is a marginal say to the executive, unlike the pre-collegial system era. Now, what are the disadvantages? Therefore, look at the first one, erosion of the principle of checks and balances. Now, once the balance is tilted towards judiciary in regard with appointing the members of the judiciary, then it hampers the principle of checks and balance. Number two, there are certain very valid criticisms of the present collegium system. And I have just made a mention of two such critical aspects. One is the lack of transparency. Okay, the process is not transparent, and lack of accountability. So yes, one that is a central advantage of collegium system is the autonomy and control of the judiciary over others. And the second, as far as the disadvantage is concerned, what about, so we can divide these 3 points into two. One is the principle of checks and balance, and other is how transparent, how accountable, okay, how reasonable, reasoned that system of collegium, that collegium system is. Now, the last part, comparison between India and the US. Just two very specific points. India, Supreme Court and High Courts through the collegium system. So, collegium system is the system of appointing judges. The executive has a very limited role, and there is no role for legislature. Okay. Now, so this is one part as far as the appointment of the judges is concerned. Now, the second one, limited tenure system we have. Whereas, on the other hand, if you look at the USA, the members, okay, are appointed by the president, not appointed, nominated by the president. So, nomination. So, what is that? Nomination by the president. But then comes the important role of the Senate there. So, there is a role of the legislature, the upper chamber of the American Congress, advice and consent of the Senate, and importantly, their appointments, that is the appointments of judges, happen to be lifetime appointments. So, these are two very important significant differences as far as the system of judicial appointments in India and US are concerned. Okay, so question number 14 is on center-state relations, but in the light of the recent developments, focusing on one important aspect of that relationship, that is the fiscal federalism. Let us read the question. Examine the evolving pattern of center-state financial relations. Let us underline the important point. Evolving pattern of the center-state financial relations in the context of planned development in India, and how, so that is first part. Okay. How far have the recent reforms impacted the fiscal federalism in India? So one is the fiscal center-state relationship in the context of planned economy. So that is first part. And the second part, the recent reforms. So, well, you can start with the 1991 new economic policy to the GST, the major one, let us say. So, how these reforms impacted again the same one, that is the fiscal federalism, fiscal union state relationship. So, these are two very important parts. Okay. So, one part broadly you can say focuses on the Indian federalism from 50 to 91, and the second part focuses on 91 onwards. Now, Indian polity witnessed multiple changes not only in the political sphere but socio-economic sphere as well. These changes have had a significant impact on the working of Indian federalism. Now, the first part of the question, the pattern of center-state relations during the planned economy. centralized planning through the Planning Commission, which emerged as a super cabinet. Okay, so Planning Commission used to be seen as super cabinet. Actually, it was so to great extent. The NDC, the National Development Council, which was established in the year 1952 for the purpose of incorporating the state in the planning process, that also failed. Okay, did not succeed in achieving its objective of involving states in the planning process. Okay. Due to the dominant role of union government, the states were heavily reliant on the union for the financial assistance. So centralized planning के अलग-अलग aspects हैं. It led to the thus over centralization of powers and proved detrimental to the spirit of federalism. Because in federalism, what we expect as far as the planning process is concerned is to give more and more participation to the states. But since the very model of planning was heavily centralized, okay, what happened ultimately? It proved to be detrimental to the spirit of federalism, leading to union-state tensions on multiple occasions. So these 4 points very precisely underline as to how financial union-state relationship panned out during the planned economy days. Now the second aspect, and that is quite elaborate. You can look into that. A new shift occurred in the economic domain through liberalization in a decisive scale in 91. India has witnessed a transition from planned to market economy, a redefinition of the role of the state, and emphasis on decentralization. Okay, and we have very elaborately explained the impact of LPG on Indian federalism, specifically the fiscal aspect of that. We have also brought in other changes as well, other issues, facets as well. One of the major milestones was the vertical expansion of Indian federal system brought about by the 73rd and 74th Amendment Act. Now, that constitutionally institutionalized in local self-governments. For example, the major cities today are altering their governance structure in order to attract private investment for the faster development. So, 2 processes. So, one is constitutionalizing the local bodies, both rural and urban on one hand, and then the LPG on the other hand. And one of the significant aspects of LPG, that is the new economic policy adopted in 1991, is the erosion of center's financial grip on the states. Okay, that's very significant. And therefore, state governments in India in general and the local bodies 91 onwards sort of attained autonomy, okay, at least in terms of raising finance from different sources. The adoption of LPG has eroded the financial grip of center over the state. That is what I just explained. Such a market-led form of development has also prompted competitive federalism in order to attract the FDI and other private investment. The state governments need to tweak the laws and rules under their jurisdiction, which are usually beyond the control of the central government. So, the competitive dimension of the federalism, and that competition is between and among the states. Okay. Sometimes that is called as the horizontal dimension. Accepting recommendations of the 14th Finance Commission, and what happened? The shareable amount went up from 32% to the 42% to be shared between the union on one hand and the states. So devolution, to be specific, the funds to be devolved to the states. The amount went up to 42%. Moreover, the centralized and directive form of planning has given way to decentralized and indicative form of planning. And ultimately, the Planning Commission was replaced with another agency, which is generally known as the think tank Niti Aayog in 2015. And look at the purpose, the spirit of cooperative federalism. The 4th point, emergence of independent regulatory authorities, that is very much part and parcel of the fiscal facet of the union-state relationship, federalism. There are a number of such independent regulatory authorities. The 7th one, the process of liberalization and subsequent integration of Indian economy have also spurred the central and state governments to agree upon mutually beneficial GST regime. Now look what Pratap Bhanu Mehta says about that. Constitutional adventure. Okay, GST is a constitutional adventure for Pratap Bhanu Mehta, and adds that this reform radically rewrites the nature of Indian federalism, ushering in the era of cooperative federalism. Okay, so this is how the following 7 points, these 7 points touch upon the second aspect of the question. And what is that? What has been the peculiarity of union state financial relationship from 91 onwards? Okay. The 15th question, number 15. What are the environmental pressure groups, and discuss their role in raising awareness, influencing policies, and advocating for environmental protection? So one hint is very important from these kinds of questions. Okay, in syllabus, there are certain points which are very explicitly mentioned. So pressure groups, say for example, but pressure groups can be classified in so many types. Okay, and one of the important pressure group which is highlighted here is the environmental pressure group. So knowing the relevant pertinent examples of environmental pressure group is essential in order to answer this question. Okay, and we have just made a mention of all these pressure groups, right from Greenpeace India to the chip code. That's a quite old one example, but very relevant. Now the role. Awareness, you can take any relevant example and elaborate upon that. Advocating protection and environment, again you can take another example. Holding government accountable, that is also a very important role played by environmental pressure groups, and it typically done, and I'm sure you must be reading regularly from Center for Science and Environment. Okay, and then influencing the policies. UPSC actually had asked a specific question on CHIPCO, okay, in terms of influencing the policy. So, 2 parts. What are the environmental pressure groups? You have to explain that with example. That is one part. And the second part is their role. Anyway, write in the questions, the threefold role already is made a mention of. So creating awareness, influencing the policies, and advocating for environmental protection. So here the pertinent cases, the pertinent examples, okay, and role is very, very essential. Now, this question again is a combination of informative part in terms of data, okay, factually even you can say, but then you have to also argue, you have to also analyze, okay, as to how something which we get to know from the data or through the data pans out in society. Okay, so it's a combination of both factual as well as the analytical argumentative aspect. Inequality in the ownership of pattern of resources is one of the major causes of poverty. Let us underline the important point here. Inequality, obviously, ownership pattern of the resources is one of the causes, major causes of poverty. Okay, ownership of pattern of resources. Discuss in the context of, again there is a concept, that is the paradox of poverty. Okay, let us take it forward. Look at the introduction. Poverty in India is a multi-dimensional phenomena. There are multiple reasons for the rise and sustenance of poverty in our society. Okay, inequality in ownership pattern of resources constitutes one of the important reasons, as it places the resourceless person in a vulnerable position. This is a proposition, and we have elaborated upon this proposition, but keeping in mind the parts of the question. Now, paradox of poverty, that is the last part of the question. So we defined right in the beginning itself, refers to India's complex situation where, despite, okay, we'll underline that part, significant progress in reducing extreme poverty. So that has happened. Okay, extreme poverty has been reduced to great extent, but a substantial portion of the population remains vulnerable and faces other vulnerability and faces other deprivations such as, look at what, poor sanitation, healthcare, yani ki poor healthcare, poor education and poor housing. So this is a paradox. On one hand, economic development is taking place, economic growth has taken place, no doubt about that, and it has contributed to reducing the extreme poverty. But nonetheless, on the other hand, and that's the paradox, a substantial section of our society is still in the position of vulnerability. And what is that vulnerability? They do not have access to, okay, sanitation, these facilities, healthcare, education, and housing. Okay. So this is the introductory part of the answer. Now, on one hand, there is a general appreciation that poverty is on decline. And we have brought in data. It is driven by the robust development spending by the government and a trickle-down effect. The Niti Aayog in its release 2024 said that multidimensional poverty, okay, has fallen to 11.3 from over 29% a decade ago. So we have brought in Niti Aayog's observation. On the other hand, inequality has risen sharply with recent studies suggesting that with 1% of richest Indians owning 40% of the wealth. And I'm sure you must be reading regularly the Oxfam report, a report by so many other agencies pertaining the inequality, the extent of inequality across the world, including India. India is more unequal than Brazil, South Africa, and the US. Now, this data is very significant. 1% of the richest Indians owning what amount of the wealth? 40%. You can imagine the scale of the inequality. The widely published study from Paris-based World Inequality Lab underscored the rise of billionaire Raj in India and underlined that in 2022-23, 22.6% of national income went to just the top 1%. So this is another figure which underlines the extent of inequality. Okay, so I guess this data is sufficient. Now look at the paradox, and we have brought in relevant examples. We have food surplus, but on the other hand, there is a farmer distress. Okay, the extreme manifestation of that distress is the farmer suicide, we know for sure. Urban billionaires, so the number of billionaires is increasing, has certainly increased, but look at the slum dwellers. That is also the part of our life. Educational expansion, no doubt about that, but look at the other side, unaffordable education. And if you brought in the issue, the facet of equality, facet of quality, then that issue becomes further complicated. Energy production versus energy poverty. Okay, forest versus tribal deprivation. Now, this is a kind of main part of the argument after pointing out the paradoxes. Due to the vulnerable economic conditions, the decent healthcare remains a luxury, while the country is a top destination for the medical tourism. Okay, yes, we know for sure. The poorest Indian states have infant mortality rates highest than those in the sub-Saharan Africa. India accounts for 17% global maternal deaths and 21% death among the children below 5 years. Now, this data is enough to point out the fact that though the percentage of poverty has come down, nonetheless a substantial chunk of Indian society is very, very vulnerable. And we have just elaborated upon the same aspect by focusing on the health sector. Okay, thus the extreme concentration of incomes and wealth facilitates disproportionate influence on society. Look at the impact. And government, it leaves poor sections vulnerable to, copy chhuta hai usme, so leaves poor sections in vulnerable conditions. So this is how we can take note of that. Now, as far as, let us get back to that question once again. Now the question is on certainly poverty. the main topic happens to be that of the poverty, causes of poverty, to be specific. But then one thing is identified right in the question by the UPSC, that is inequality in the ownership pattern of resources. Inequality in the ownership pattern of the resources. So in what way that inequality highlights the paradox of poverty? Okay, so poverty is the larger circle. Then this being the one of the major reasons of the poverty, one of the major causes of the poverty, that is the inequality in the ownership of resources. And you have to fit in something called as a paradox of poverty. Okay, and that is what we have done. The introductory part, then the data from both the aspects, and then the paradox, the concluding argument. Okay. The 17th question is on per se the developmental models, and this is very explicitly mentioned in the syllabus. Now, in contemporary development models, decision making and problem solving responsibilities are not located close to the source of information, and execution defeating the objectives of the development. Let us point out the important parts. In contemporary developmental models, yes, okay, what are we talking of? Decision making and problem solving, fine. Responsibilities are not located close to the source of the information. Okay, plain and simple, in contemporary developmental models, decision making is done as if from distant places. Okay, and there is a huge gap between the source of information, that is the locality, the local people, okay, the ground reality, so on and so forth on one hand, and the policy making process on the other hand. There is a huge gap, there is a huge rift between the two. So that is something which is focused in this question. Information as a critical input in the making of public policy. There is no doubt about that. In this regard, the nature of information, its source, quality, reliability have a deep bearing on the design and implementation of the public policies. We have made a mention of different aspects, facets of the information. So, क्या क्या है उसके देखिए, the nature of information, to be specific, its source क्या है, उसका quality क्या है, and the reliability have deep bearing on the design of the policy as well as the implementation. However, now if the decision making takes place from a distant place, that is away from the source of information, then not only the design of the policy but implementation is likely to remain utterly defective. Okay, now look how we have established that. Many contemporary developmental models still follow what kind of decision making? Not a decentralized one, but a centralized one, which is disconnected from the local information. This mismatch leads to policies that are not context specific and ultimately leading to inefficiency and failed execution. Okay, if there is a dissonance between the policymakers on one hand and the local source of information on the other hand, and this is what going to be the consequence. Now, in the era of globalization, the policies are generally framed at the higher elite institutions, mostly the corporate houses, yeah, MNCs, which are unaware of the local realities. And both, they are unaware and they also deliberately neglect the realities. As a result, the policies are not reflective of the local preferences or the local needs. Third, the public policies that are not rooted in the local information are likely to turn out to be unreflective of the sensibilities and cultural ethos of the people. आपको अगर लोकल इन्फॉर्मेशन ही मालूम नहीं है या आपने नहीं लिया है, तो उनका सेंसिबिलिटी क्या है, उनके कल्चरल नॉर्म्स क्या है, ये आपको कैसे पता चलेंगे. So that is the third major defect, okay, that we get to know. The fourth one, moreover, the process of depoliticization that has taken place in the regime of LPG. This is a very significant aspect of the impact on the policy making of the liberalization process. And what is that? Depoliticization. Whichever party comes to power, okay, there are inherent limitations on the given political party while framing policies, because your state is officially committed to LPG. तो आपको तो कितना स्पेस बचेगा? Okay, even if tomorrow, imagine a left political party comes in power. So how far, to what extent the present policy of LPG of the Indian state is likely to be changed, likely to be replaced? Okay, we cannot answer this question positively. Okay, it is very, very difficult. So in that sense of the term, since the Indian state is officially committed to LPG, then there remains no space as if, let us say, आप ट्विक कर सकते हो इधर उधर, लेकिन आपका जो डिजाइन है पॉलिसी का, वो डिजाइन आपका एलपीजी न्यू लिबरल आइडियोलॉजी से ही कमिट करेगा. नीदर द गवर्नमेंट नॉर द लोकल पीपल हैव अर्लियर, देयरफॉर एज लुक एट द कॉन्सिक्वेंस, हैव द अर्लियर ऑटोनॉमी इन द फ्रेमिंग ऑफ पॉलिसीज, क्योंकि उस फ्रेमवर्क के बाहर आप नहीं जा सकते हो. यू हैव टू फॉलो द लॉजिक ऑफ एलपीजी. ओके, एंड दैट इज हाउ we have seen significant erosion of the autonomy which earlier used to be enjoyed by the state and the people. Now, what are the issues here? Which issues and challenges? If policy making is located away from the source of the information, leakage kya hai phir in the backdrop of that. So we saw the consequences. Now, what issues, what challenges do we get to see? Bottom up approach. Okay, so to ensure, so you can look at it as a way out, you can look at it as a measure, you can look at it as a reform. So bottom up approach, और ये challenge भी है, because if the policy making is still centralized, if it is done by the elite institutions away, miles away from the realities, then bringing in bottom up approach becomes a challenge in itself. Ensuring reliable and accurate information, yes, that is again an issue, a problem, and therefore a challenge. Management of information, that is also equally important. Building adequate local capacities, adapting to the rapid technological changes. Okay, therefore look at the conclusion. Public policies need to be located near the source of information so that the information gap, that conclusion is important, information gap could be bridged and policies could be framed and implemented in an appropriate and effective manner. Okay, so what kind of relationship, what kind of connection, what kind of connect one should expect, or we generally expect between two locations, let us say. So one is the policy making and the other is the sections, the regions for whom the public policies are to be made. Okay, so that ground reality, the participation of the people, the stakeholders is equally important. Okay, so this is how we can take it forward. Now, this is a very interesting question. Now, per se, it seems that the question is about the National Commission for Protection of the Children. But the manner in which the question is designed, that is very interesting. The National Commission for Protection of Child Rights has to address the challenges faced by children in the digital era. And you can try to remember or recollect those 10 observations. Okay. Now, per se, the question is on the commission, but there is a specific context which is brought in, which is referred to here. And what is that specific context? The digital era. Okay. The challenges. Now, obviously, National Commission for Children has to look into, okay, the issues faced by, challenges, problems faced by children, no doubt about that. And we have number of issues and challenges faced by children, and therefore authority and responsibility given to the commission, no doubt about that. But here comes the specificity, that is the digital era. Examine the existing policies, okay, and suggest measures the commission can initiate to tackle the issues. Okay. So make it simple. We can divide the question into two broad parts. So one part is about the challenges faced by children in the digital era. And the second part, which is equally important, can be divided into two subparts. Existing policies. Okay. You have to assess that. Okay. And then the second subpart happens to be what measures would you suggest? अब देखिए, let us take it forward. Rapid digital transformation is what the the present world is known for. Challenges faced by children in the digital era. You can be that specific and very precise. Exposure to screens at a very early age, digital addiction, exposed to harmful and inappropriate content, sleep disturbances, look at the consequence, reduced physical movements, okay, obesity, cyberbullying, privacy risks, misinformation and disinformation, and ultimately the mental issues. So this is an elaborate list of the challenges which are faced by children in the digital era. Okay, now the conclusion: harmful to the healthy development of a child. Now, evaluation of the existing policies and measures. Niti Aayog in 2025 has come up with a very interesting document, and this part is taken from Niti Aayog's document. So, आपको नीति आयोग के ऐसे कोई डॉक्यूमेंट्स होते हैं जिसका जिक्र न्यूज़पेपर में किया जाता है. So we have to pay attention to that. Now, National Cyber Crime Reporting Portal under the IT Act of 2000, Indian Cyber Crime Coordination Center, Cyber Crime Prevention Against Women and Children, Information Security Education and Awareness, Stay Safe Online Campaign, and Cyber Dost Awareness Initiatives. So these are few policy initiatives and certain campaigns. Okay, I have just made mention of these campaigns. Okay, now challenges for parents and policymakers, and on the basis of these challenges that we can evolve our agenda of measures, the possible measures, possible reforms which can be taken up. Setting clear boundaries, okay, then fostering a culture of digital responsibility. These are the measures. Leveraging technological tools, enforcing age verification measures, holding tech companies accountable for content shared on their platforms, and providing resources for parents and children to learn about online safety. Hence, a robust and reliable policy regime is the need of the hour. Okay, now as far as this part is concerned, please focus on this part. You have to prepare on each of that, because this is a policy regime, and we have to also include one more critical paragraph. Now, okay, fine. With the 2000 IT Act, a lot of measures been taken, no doubt about that. But what has been the performance of the same? So the performance has not been, the working has not been up to the mark. And therefore, we keep on hearing about different frauds, misuse of the platforms, so on and so forth. Keeping in mind, we have to think of the possible measures, and that is what we have done in the file. So this is the last question. Now let me get back to those 10 points once again, okay, so that we can focus on evolving the right kind of strategy. Yes, okay. A combination of static part and current events. You must have now realized that except that one question on Attorney General, all questions can be seen as a combination of the static factual part on one hand and the current contemporary part on the other hand. So please always keep in mind the way in which questions are combined, or topics in questions are combined in this manner. Again, even if a particular topic is asked in the question, some specific dimension, for example, the challenges faced by children in the digital era. So that digital era, the particular aspect. Okay. There was a question on administrative tribunals, and that was asked in relation with the recent development in 2021, the rationalization of the administrative tribunal system. The third observation, the current events are not limited to only 2025, that is the current year, the previous year 2024, but rather UPSC is taking you back 5 years, 10 years, okay, in regard with the developments. Therefore, not current per se, but you should use the word something called as a contemporary. Okay. Then the fourth one, there is another combination. Concepts are referred to, but those are combined with analysis. Okay, so you have to analyze something, you have to argue. Okay. Fifth one, undoubtedly, there are few questions which seek to cross-check your critical thinking ability and the ability to argue from this point of view or that point of view. Okay, so this is also important. Application of the concept, and the very specific question is question on constitutional morality. So how can we apply that and have a balance between judicial independence on one hand and the judicial accountability on the other hand? So application of concept. So two quick things. We should have utmost level of conceptual clarity, but nonetheless, we should also develop the ability to apply those concepts to relevant domains. Then the seventh one, that is very explicit and obvious one, but let us focus on that because this is going to matter a lot. Except 2-3 questions, every other question, the remaining question, maybe 10, 11, 12, the number can be or would be examples, cases, case laws, experiments, models on one hand, and relevant data on the other hand. Now, question on inequality, paradox of poverty, then the challenges faced by children in the digital era. Okay, these questions demand relevant data. Okay, then specific issues and problems along with few general problems. So we saw in connection with, again, I'm referring to the same question, that is the challenges faced by children in the digital era. A very few questions were asked on constitutional provisions, that is the static question, just one question, that is the Attorney General. But all other questions, okay, thoda sa exception ho sakta hai, focus on the constitutional process. That is the working of the Constitution of India. Okay, now when we say working of the Constitution of India, then we have to take note of the constitutional and legal aspect of the same. Okay, number one. Number two, the political factors are to be taken into account. Number three, the economic factors also are to be taken note of. Before I conclude this session, we got to know as to what kind of questions were asked by UPSC this year, number one. Number two, these 10 observations are critically important because on the basis of this, that you are going to design your strategy for the coming years. Okay. Number three, reading static material from standard references is not going to be sufficient for you. You have to regularly read on yourself, on your own, the original sources, let us say the primary sources, newspapers, journals. You cannot rely on ready-made material. You have to refer to the sources besides the fundamental reference book, such as newspapers and journals, and process the current events, the contemporary events pertaining those topics on your own. Okay, because on one hand, very generic aspects are focused by UPSC, but nonetheless, on the other hand, very specific dimension of the given topic are also focused by the UPSC. Very few questions on static part, but number of questions on the current contemporary parts is what asked by UPSC. Now, this requires a strategy which does not limit to only the fundamental sources, but even incorporate the current and contemporary process. Now, the last point, reading these sources, processing these sources, and importantly, transforming that material into relevant material, relevant aspect of a given topic is going to be the real test for you. Okay. So with these words, let me stop here. Thank you.